This bill cannot possibly provide the safeguards that it claims to provide for the reasons addressed by Sir James Mumby, the late president, or the last previous president of the Family Division of the High Court, for reasons that have been set out in numerous cases. The safeguards are simply not safeguards at all. In addition to that, diagnosis of whether the patient is going to live for 6 months, whether they have an incurable condition, these are all imponderables that cannot be addressed by mere legislation. And the whole thrust of the bill is away from what we should be concentrating on, namely palliative care, towards what is effectively a counsel of despair, namely, there's nothing we can do for you, go away and die. That is not an appropriate or responsible way for a proper democratic parliament to legislate. I have been involved in quite a number of end-of-life cases involving mentally incapacitated adults, children, and other public law cases of a similar nature. This is part of my practice. I also have other parts, health-related and otherwise, and so I've taken a certain interest in this assisted suicide bill. And it has, as I've discovered from reading the bill, a very large number of flaws in it, which make it, frankly, completely unworkable. Now, in the Diane Pretty case, Diane Pretty, who was suffering, I think, from motor neuron disease, feared that in the latter stages of her life, as very similar to the Annie Lindsell case much earlier, that she might suffer intolerable pain in the latter stages of her life. Now, given the current state of palliative medicine, there is in fact no need, provided you get the proper palliative care, and that's where the problem lies, for anybody to suffer pain in the latter stages of their life. Even Diane Pretty in motor neuron disease, and as I understand it, when she did die from MND, she did not suffer in the way that she envisaged, or indeed very much at all. But she wanted to avoid that, and so she wanted her husband to be given legal permission in advance by the Director of Public Prosecutions to assist her suicide, without saying exactly how he would assist her, so that it left the door open to the possibility that he might do rather more than assist. He might actually actively become party to or involved in a homicide. The case was heard as a case with criminal ramifications by the Divisional Court of the High Court. Then it leapfrogged over the Court of Appeal to the House of Lords, being a case of criminal jurisdiction, and then from there it went to Strasbourg. And not one single judge was in favour of what Diane Pretty or her husband were proposing, because of all the very safeguards that I've been touching on that simply could not be guaranteed, cannot be guaranteed, and never will be guaranteed. And that is why this is an impossibly flawed bill, and no amount of tinkering in committee or at report stage, or indeed in the upper house, is going to be able to rectify those problems. One of the, just to take the beginning of the bill, I have it here in front of me, paragraph 1.2 of Kim Leadbeater's bill says that the patient has to have a clear, settled and informed wish to end their own life, and has not been coerced or pressured by any other person into making it. These are going to be very, very difficult things for anyone to determine, whether a doctor or whether a court. And this has been heavily emphasised by Mr. Justice Mumby, or Sir James Mumby, now retired judge, when he commented on the Leadbeater bill, and in particular the role that it envisaged originally for a High Court judge to participate in the process. That, of course, has now been removed from the bill, but the same sort of arguments that he raises will apply to the panel that they're proposing to replace the High Court judge with. But he cites, for example, the case of Conway, the Humanists UK and others, judicial review, and he in particular cites the Divisional Court as being sceptical about the proposed safeguards that Mr. Conway was suggesting. And the Divisional Court said this at paragraph 100 of its judgment: the involvement of the High Court to check capacity and absence of pressure or duress does not meet the real gravamen of the case regarding protection of the weak and vulnerable. Persons with serious, debilitating terminal illnesses may be prone to feelings of despair and low esteem and consider themselves a burden to others, which may make them wish for death. They may be isolated and lonely, particularly if they are old, and that may reinforce such feelings and undermine their resilience. All this may be true while they retain full legal capacity and are not subjected to improper pressure by others. And they go on to quote Lord Sumption, a Supreme Court judge now retired, in the case of Nicholson against the Ministry of Justice in 2014, in which he said, quite rightly in my humble opinion, the intervention of a court would simply interpose an expensive and time-consuming forensic procedure without addressing the fundamental difficulty, namely that the wishes expressed by a patient in the course of legal proceedings may be as much influenced by covert social pressures as the same would apply more generally in relation to external pressures exerted by others on the person concerned. The process of seeking approval from the High Court would not be a complete safeguard. And I pause to add, or by an independent, supposedly independent panel. Lord Sumption went on to say external pressures might be very subtle and not visible to the court. For example, it's not difficult, said Lord Sumption, to imagine cases of family discussions about money problems, not necessarily intended to place pressure on an elderly relative, in consequence of which they draw their own conclusions that they are a burden and would be better off dead. In any event, it might be difficult to disentangle factors of external pressure from the individual's own internal thought processes, and difficult to tell when external pressure is illegitimate or such as to invalidate the individual's own choice to die. Now, those are in pre-existing cases, which in some cases long before this bill that's being proposed by Kim Leadbeater, and yet they are absolutely valid points being made by the Supreme Court and by the Divisional Court of the High Court, and which apply to her bill with even greater force, as Sir James Bogle went on to say when he was criticising the bill. And none of this has been properly addressed, nor, in my respectful submission, can it be addressed, because the problem is frankly insoluble. And although Sir James Bogle doesn't quite go so far as to say that, nevertheless, it is implied in what he is saying to some extent. He, remember, was a former president of the family division of the High Court, and he has described the whole approach taken by the bill as follows, and I quote, "A profoundly unsatisfactory scheme for judicial involvement," and I pause there to say, or involvement by a panel, "a scheme which does not provide for an open and transparent process, but on the contrary permits a secret process which can give us no confidence at all that it will enable the court to identify and prevent possible abuses." But he then later on goes on to say that it's a dilemma which can't really be resolved. And he says whether it is open and transparent or whether it is secret, both will be unsatisfactory. And he said, and again I'm quoting from him, "The hard truth, as I previously suggested, is that in contemplating judicial involvement," and again I pause to say, or the involvement of a panel, "we face an impossible choice between an open and transparent process that might deter those for whom the scheme is designed, on the one hand, and a secret process destructive of the integrity of the scheme and corrosive of the judicial function, or the function of a panel. Despite its being promoted by its supporters as an important and valuable safeguard in which the public can have confidence, on the contrary, it permits a secret process which can give us no confidence that it will enable the court, or for that matter a panel, to identify and prevent possible abuses. He also points out that the proponents of the bill have simply not done their homework, or for that matter, their arithmetic. He says, let us assume, in order to illustrate the scale of the problem, that each application takes an average of 2 hours. I make it clear, he says, that I do not accept that 2 hours will be sufficient. That would require a total of 34,000 hours of judicial involvement. Same for a panel. He says, including the president of the family division, there are 19 judges in the family division, between them sitting a total of 19,000 hours a year, a figure far short of the 34,000 hours of time required to handle this problem. So the figures speak for themselves. It is, in terms of resources, in terms of management, in terms of logistics, a total impossibility. He says, in answer to the question, how confident can we be that the procedures set out in the bill will be adequate to enable the court, or for that matter a panel, to identify and prevent possible abuses, and in particular be adequate to detect what may be very subtle external pressures, echoing what Lord Sumption said and what the divisional court said. And he says, only those who believe implicitly in judicial omniscience and infallibility, and I do not, he says, can possibly have any confidence in the efficacy of what is proposed. So he is highly critical of the proposals. He sets out in more detail exactly why it is, but in essence, just quickly running through the issues as he sees them. What level of judge is required to exercise the jurisdiction? What is the function of the judge? Same to be applied to the panel. To what extent is the judge or the panel expected to exercise a discretion? Who can apply to the panel or the court? Who should be joined as parties? Is there to be a hearing, or is it to be dealt with on the papers only? Should the patient, the witness, and the countersigning doctors be anonymized? What procedures are to be adopted for testing and, if need be, challenging the evidence? Who should exercise that function? Is there to be an independent evidential investigation? If so, who is to undertake this and who is to pay for it? Should the judge or the panel be required to give a judgment in every case and be required to publish their judgment? How are appeals to be incorporated in the process? What public funding arrangements will there be? And then he says, even assuming the adoption in every case of the most rigorous procedures, how confident can we be that even the most rigorous procedures will be adequate to identify and prevent possible abuses, and in particular, be adequate to detect what may be very subtle external pressures? Again, echoing the very important points made by the Divisional Court and by Lord Sumption in the Supreme Court. He asks another important question. Does the conscience clause apply to the judge or to the panel? If one's appointed, say if it's a panel appointing servants of the crown, can they say, no, I can't do it? The doctors have a conscience clause, as do other individuals named, but there's no mention in relation to judges or the panel. Is what is proposed a proper role for a judge or a panel anyway, given that their function is not to decide some disputed issue or resolve some controversy in this situation, but only to certify that the decision taken by the patient complies with the law? Those are just some of the problems he identifies. He says, he also remarks upon the quite extraordinary provision that was in the bill. I believe it's now been removed, but was in the bill to the effect that when a High Court judge makes a determination, now a panel, there will be no appeal from it. And what happens if, as in the Canadian case of AC, during the course of the process and after a decision had been made, the court had to issue an injunction to prevent the assisted suicide from taking place because a considerable number of errors, problems, and external pressures and other matters that would invalidate the whole process were discovered. But under this process and under this bill, there would be no appeal. How then, if there is a need for there to be a review by the court and for the evidence to be reviewed again because of some later evidence, how will that be dealt with? Quite clearly, if it's not dealt with, then somebody may find that their life has been terminated improperly and wrongly, and perhaps even against their real wishes. That is quite an extraordinary provision. But it arose in the Canadian case of, I think I said AC, but it's AY against NB in 2024, last year, BCSC 2004, where the patient's partner intervened and obtained an inter-injunction because of concerns about what was happening. The whole thing, says Sir James Bogle, is completely inadequate. And he says the absence of any requirement that the judge must hear and question the patient himself or herself is a quite extraordinary lacuna. So he says, in effect, if there is to be a hearing, well, summarizing it, the real concern there, he says, in short, an application could be dealt with in accordance with a wholly inadequate procedure and without the public knowing about it, nor even the name of the panel or the judge. He says the panel and the judge could decide the matter without hearing from the patient, with no input of any sort from the patient's partner or relatives, could deal with the case in private, in secret, and if he's right about clause 12.5b, without holding any kind of hearing, and moreover, without giving any public judgment that is published and then made available to the public. It could adopt a procedure which, beyond whatever little the judge is required to do, or the panel, in accordance with clause 12.5b, involves neither testing nor challenging the evidence, nor any independent evidential investigation. And as soon as you go down the route of having an independent investigation, as soon as you go down the route of carrying out these investigations, you invent such an incredibly large logistical problem that it becomes hopelessly impractical, so that we then go back to the position that he originally adumbrated, that the whole idea and principle behind the bill is wholly impractical, quite apart from the obvious medical ethical problems that it throws up. Now, what are those medical ethical problems? Well, it drives a coach and four through a number of very fundamental principles that underlie not only our health service and our medical practice, but also our legal practice. It would deny the fundamental right to life. It has been argued in a number of cases, certainly in the Diane Pretty case, which I appeared in, that by those who argued the case on behalf of Diane Pretty, that a right to life implies a right to death. And the Divisional Court, House of Lords, and the European Court all said, no, it does not. That is not a logical corollary of the right to life. And indeed, Lord Justice Tuckey said in the Divisional Court in that case to Mr. Philip Havers, who was arguing on behalf of Diane Pretty, so are you suggesting that the government would then be obliged to provide an official who would be responsible for making the right to die available to citizens? If you like, a sort of Lord High Executioner, if I can put it in a slightly comical way, who would not do the executing himself, but would make available the means for the patient to do it themselves. Well, that is in fact what this bill is now proposing. And yet the Divisional Court, the House of Lords and the European Court set their face very firmly against that. There can also be no effective safeguards for the reasons that Sir James Bogle outlines, and for the reasons that the Divisional Court and Lord Sumption set out. And the confidence of the public in the medical and nursing professions would inevitably be very seriously harmed, because the principle that has hitherto governed medical and nursing practice is that whatever you do, you don't harm people. The aim and purpose of the profession is curing, alleviating pain and suffering, not harming. And this will drive a coach and fall through that. So I don't think that the proponents of the bill realise quite the extent to which they will be overturning absolutely vital safeguards in the law and in medicine. And if there is nobody else present, apart from the doctor and the patient, how will we know what the doctor actually did? Given that the patient, provided of course the poison is effective, and that is another problem, if it's effective, the patient will be dead and will not be available to give evidence. One of the biggest problems in this whole bill is that the person at the centre of the case, if anything goes wrong, will not be there to come back and give evidence. They will be dead. The bill itself is reflective of debates that have been had in the past, and had with very, very unsatisfactory results. I suppose the most obvious is what resulted in, at the tail end of the 19th century, beginning of the 20th century, a book that gained a certain notoriety by Dr. Alfred Hocker and Dr. Carl Binding, called Permission for the Release of Life Unworthy of Life, which the book was published in Germany, in German. Alfred Hocker was a German psychiatrist. Carl Binding was a German jurist. And out of it was coined this word, life unworthy of life, lebensunwertes Leben. And that became quite a popular word in the 1920s and 30s, so that you had a growing, it was adopted, if you like, by the growing eugenics movement, a movement that was not confined to Germany, by the way. It was very popular in Scandinavia, in America, even to some extent in this country. And it led to a belief that certain medical practices that we wouldn't now even begin to countenance, like sterilization of the mentally ill or unfit, would lead to some new super healthy population. And equally, at the other end of the scale, that those who were deemed subhuman or mentally unfit or terminally ill or suffering from an incurable or chronic disease should have their lives terminated for the benefit of society at large. Well, now, I'm sure that is not Kim Leadbeater's motivation, but the terms of her bill reflect in many ways the terms of bills that were proposed in America, in various states in the 1920s, in, for example, Denmark in the 1920s and 30s, and in other states, and of course, notoriously in Germany, with results that I don't need to go into. Everybody knows. We need to be careful and ask ourselves, well, just exactly what direction are we going in if we are even talking about legislating along these lines? And what I would suggest is that a bill like this is really a counsel of despair, and a very unnecessary counsel of despair. We don't need to say to somebody who is terminally ill and is depressed about it, or has a long-term or chronic illness that cannot be cured, well, the best thing for you is to die, or to encourage them, even by the most subtle methods, to think that way, or even to allow them to think that way, when in fact what we should be doing is providing them with the appropriate palliative care and allowing them to die naturally in the course of time